Anita Baker, and I see Attorney Sam Aguilar also here.
Okay.
We represent the family of Breonna Taylor.
All right. And I believe Mr. Moore was also noticed to be present. I don't necessarily see him on the line, but if he is there, I know he was noticed to be here. Let's see. All right. Okay. Mr. Glogauer, on behalf of Anonymous Grand Juror number 1, go ahead. Sorry.
I'm not sure what Mr. Maddox is waving at the camera. I don't know if he needs something.
Thank you.
Sorry.
I was muted and it said the host was not allowing me to unmute. So
You did exactly the right thing. For some reason, my
No.
Zoom settings are like that right now, and I can't figure out how to undo it. So just wave at me if you need my attention.
thank you, Your Honor.
Got a hand up from Mr. Bramall.
Mr. Bramall.
Yes, Your Honor, I just wanted to let you know Carol Pettit was having the same issue. She wanted to announce her appearance on behalf of her
Okay.
client.
All right. Thank you. Okay. Now are we ready? Mr. Glogauer?
Thank you, Judge. Please the court and the technological gods in charge, I guess. Judge, I'll state initially for the record that we're in receipt of the Attorney General's response. I believe it was filed late yesterday. It came to my email right around 5 o'clock. It was about 22 pages long. We've had some time to go through it, and obviously we'll follow whatever directions the court gives as far as where we go after this hearing. But quickly, in going through their motion, the first thing that they bring up are some procedural issues, specifically as they mentioned on the motion hour. They raised an issue of service. I think the court actually addressed that at motion hour, that obviously there was actual service. But I would point out as well that the reason behind service is to notify people what the filing is and give them an opportunity to respond. I think we can all agree to that. And I would point out to the court, the Attorney General himself put out a press release approximately 5 hours after we filed the motion on September 28th, I believe it was, and specifically addressed the motion in that press release. So I don't really think service is an issue. Obviously, the Attorney General's office is well aware of the motion and what it contained very quickly after it was filed. They also point the court to 4102 and their ability to ask the court for a dismissal if certain rules aren't followed. First, I would point out, as the court well knows, that is permissive language in 4102. It's not in any way mandatory. So while I respect their position and they're entitled to request that, I don't think it's appropriate under the circumstances. And again, I think it's an issue where this was properly put before the court. They're adequately put on notice. It was a declaratory action housed within a grand jury motion. So it's a little bit novel because it's not an independent civil action, for damages or something of that nature. It was housed within that motion, which they're now arguing is moot, but obviously not the declaratory judgment portion of it. I would also point out they next want to talk about standing, I believe is their second defense alleged in their response. Consistent with the Attorney General's messaging from the outset of this indictment for Mr. Hankerson, they don't really always give the full law or all of the rules that are relevant to what they're arguing. Later in their motion, they bring up the case out of Missouri involving the Michael Brown jury, which I can distinguish later, and we'll get to that a little bit more, the meat of it. But what they don't talk about is the language regarding standing that's in that case. And before I forget, let me just remind everybody, and I know we all agree, again, that's persuasive authority. It's not mandatory. We're not bound by what happened in Missouri. But I think it's important to note, since they're going to argue it from a different perspective, that, and I'm quoting Doe v. Bell, which is the Eastern District, Missouri case that was from 2019. I think that was the first case they attached to their motion, that states, to establish standing, a party need not expose himself to actual arrest or prosecution to be entitled to challenge a statute that he claims deters the exercise of his constitutional rights. But he must show that injury is more than imaginary or speculative. It goes on to state that a juror's fear of prosecution is not speculative or imaginary, and especially in light of the possibility of being held in contempt, in addition to being subject to criminal prosecution. little ellipse there and pick up the quote again. As a result, the juror was found to have standing to bring that claim. So I think by their own case that they've attached to their filing vitiates their argument about standing. It's a very similar analysis there to what we're raising. And obviously in our motion, we contemplated potential contempt. I would imagine, as they did in their motion's response, they will also state that it would be Your Honor or another court that would actually hold them in contempt, and that the Attorney General's office would not be the direct cause of said contempt, which is within the case law, both in Kentucky and elsewhere. There is that issue to be addressed. But again, practically the way that occurs is the Attorney General could, and by indication of their 22-page response, very likely would move the court to hold the juror in contempt, which is their direct action. So I think that there's clear standing here. And I think it's a little off point to try to argue that it's the court alone that would act to hold them in contempt. It's going to have to come from somebody raising that issue. And of course, we all know the courts have the power to sua sponte, do whatever they so choose within the bounds of the law. But that's not what the point of our motion was. It was to declare the rights and the duties of a grand juror in relation to the response of the Attorney General, and specifically in response to certain statements that have been made publicly by the Attorney General. I think the meat of our motion versus their response is contained within their third bullet point, which is regarding the high burden. As this court well knows, mostly I do criminal defense, so I get to actually say something prosecutors say for once. We will gladly accept the high burden. We think that this case meets the criteria to overcome the longstanding tradition of grand jury secrecy. They quote, and they are accurate in the choice of case to cite, U.S. versus Procter & Gamble. It is the seminal case on grand jury secrecy, and it lays out the 5 things or 5 reasons behind why that is the case. It's the 5 reasons they're sort of hanging their hat on. It's the 5 reasons that the attached statement from the Association of Commonwealth Attorneys stated as well. And I'll go through them one by one because it's the easiest way to do it. The first one is to prevent escape. We don't have that issue here. That does not apply at all. The only indictment that's been rendered is against Mr. Hankerson. His lawyers are on the line. He surrendered. He's posted bail. We all have every belief that he's going to come back to court regardless of whatever else may be talked about regarding these grand jury proceedings. The second criteria is to ensure the utmost freedom of the grand jury so that they may avoid harassment. And I think that actually applies here. But what's happened is they've flipped it. Grand jurors are now in a position to potentially and very likely be harassed by everyday citizens because of their service on this jury, this grand jury for the Attorney General, and the way things have been hotly contested and continue to be talked about in the streets of Louisville and across the country. The Attorney General put that in issue during his press conference right after this court read the indictment. He's made very definitive statements about what the grand jury did, what their decisions were. He discussed certain evidence that was presented, why they believed some evidence was more relevant than others. Quite frankly, they opened the door, to use a phrase we all overuse, but they opened the door to the discussion of all things grand jury by that very press conference. Not to mention, they keep making press statements regarding what happened in the grand jury, supplementing them, adding facts, discussing different evidence. And what, again, if you look at that second prong under Procter & Gamble, it uses language so that the jury or the jurors are not importuned by everyday citizens, which sometimes, of course, means harassed or somehow goaded into doing something or not doing something. And I think one way to look at that is what the Attorney General's office is doing, is that they say that this is important because we don't want future grand jurors to be harassed to do or not do something, to vote one way or the other. This grand jury's finished. Their service is finished. They don't have any more cases to do. They were here for the month of September. That time has passed. They have been discharged. So the only harassment and importuning of these grand jurors would be to their detriment as citizens within the Commonwealth, to hold them to task for whatever the results are, and potentially to be held to task by the Attorney General's office for desiring to speak out to help clear up what happened or what didn't happen during these proceedings. The third part of Procter & Gamble is to prevent suborning perjury or tampering with witnesses that may testify at trial later. I would submit to the court that that doesn't apply any longer in this particular matter because the grand jury recordings have already been released to the public. They're on various media websites, probably the Attorney General's website. I didn't check myself. I have a copy of it. I know many, many people that have been listening to it, commenting on social media. So any witness testimony that needs to be preserved under Procter & Gamble has already been let out of the bag. And just for understanding for everybody in the court as far as timing goes, when we filed this motion on behalf of our client on the 28th of September, we were unaware that Judge Ann Bailey Smith was going to issue an order releasing the proceedings. I believe it probably happened within 20 minutes of the arraignment time and our filing, which we had no knowledge of. But at that point, the order was issued and the Attorney General did not fight Judge Ann Bailey Smith's order. They submitted to it. They, of course, put out a press release that made it sound a lot more forthcoming than maybe it was, but they submitted to that order and they agreed and then did not take a writ, did not challenge it in any way to let those things out. So at that point, the only other thing that happened was certain witness names and phone numbers were redacted, appropriately so, but their testimony's out there. And, people that are close to other people in this community are not going to have to take too many steps when they hear voices they know, et cetera, to try to figure that out. But I would submit, even beside that point, the fact that it's been released gets around that third criteria listed in Procter & Gamble. And again, the Attorney General had opportunities to argue that a different way, to strengthen that argument, to really rely on that prong. But by submitting to the order, making statements that no problem releasing the proceedings to the public because they're so confident in their presentation, that no longer applies. The fourth prong in Procter & Gamble is to encourage the disclosure by those with information in respect to commissions of criminal acts. And I would imagine they're going to make a bit of hay here, or try to anyway, because that's more about future grand juries. And I think both sides have been using some of the same language publicly, that we're concerned about a chilling effect. In fact, I know that Mr. Cameron, during different media appearances, has said exactly that they don't want to chill the future grand jury proceedings by allowing any more to come out than already has. But what we have talked about previously and what we mentioned in our motion prior to hearing any responses, and we would submit to the court, is still the case. If what actually happened is not accurately portrayed to the public, since so much of it has been discussed by the Attorney General and obviously by the public, but directly from the Attorney General himself, if that is not allowed to be cleared up and made unequivocal and unambiguous as to what was presented, what wasn't presented, what recommendations were made, which weren't, et cetera, then you're chilling future grand jurors who are not going to want to be thrown under the bus by a prosecutor at some point. If there's another high profile case in this county or anywhere else in the Commonwealth, a grand juror is going to be a lot more reluctant to participate in that proceeding and give it their most earnest efforts if they have the same concerns that our client has based on what portrayed by the prosecuting authority within the public mere moments after their service is complete on a case of that nature. Those are all five of the prongs under Procter & Gamble that I would submit to the court and actually favor our motion, and have been undone by the Attorney General. They've undone their own argument as far as the secrecy there. They further cite in their response Douglas Oil Company of California versus Petrol Stops, which I believe is 441 US 211 from 1979. that the need has to outweigh the public interest of secrecy before we can meet our burden. And I would submit to the court that the need here does absolutely outweigh the public interest for secrecy, because the public interest has completely shifted in this matter. And it has shifted for two reasons. First and foremost, because they've undone the secrecy. The moment the Attorney General stepped to the podium and discussed evidence, witness statements, compared it to other witness statements, and made definitive remarks about what the grand jury decisions were and how they applied certain facts to their determinations, completely undid secrecy, as I keep stating. I realize I may be getting a little redundant, but it's a very important point. And the public interest then shifted to transparency and public trust within the process of our legal system, which is absolutely 100% what precipitated our client's motion, and what was a big part of all of the conversations that were held when our client was making that decision. With future effects in mind, and the fact that both sides discuss it and that chilling factor, there's more language, I believe it's in that same case, that a fear of future retribution or social stigma may act as a powerful deterrent to those who would come forward and aid the grand jury in the performance of its duties. It's a little more witness centric, but that language certainly applies here to future grand jurors. The fear of that retribution and social stigma. That's exactly what Attorney General Daniel Cameron laid upon the feet of the grand jurors at that press conference, when he stood at a podium and told everybody that was watching and everybody in the room that the grand jury made certain decisions. And the only caveat to his putting all of that burden onto these grand jurors was to state that his team believed that Mattingly and Cosgrove were justified in their actions, and I quote, "The grand jury agreed." These are issues that need to be addressed head on, directly, unambiguously. In that press conference, the Attorney General was asked very pointed questions about those statements and completely deflected them, dodged some of them entirely, refused to answer. These are things that grand jurors can and should be able to weigh in on. And I think it's important at this portion of the argument that we all make sure that we realize their service is finished. Mr. Cameron more than once has made statements, and it's even in a footnote on the very first page of their motion, that they have no concern about grand jurors discussing the proceedings or their presentation. It depends on where you read it, on how they word it, because they're being careful now because people are watching and raising issues. But if he has no concerns, if their office has no concerns, then I'm not really sure why we're having this hearing or why they filed a response. Clearly, there's something left that the Attorney General is concerned about. And it would appear by the messages that are put out in the public that it's those very statements that we're pointing back to from the press conference and the subsequent walking back of some of those statements in his WDRB interview the Tuesday after we filed our motion. So again, if they want to talk about service, within less than 24 hours, or maybe slightly more, they send out a written press release and appear on WDRB in an exclusive interview. It's at that point they finally state what their recommendation was, but it's still unclear the presentation and how they actually handled some of those discussions. This is the point in their argument when they're talking about the secrecy that they point to Missouri. And they point there that it is one of the only similar cases that is out there. That's true. We'll give them credit where credit's due. We came across that in our research too, but it doesn't apply here. It's not a mandatory controlling case that governs what we do here in Kentucky. But what's different here, and we'll cover this a little bit later in the argument, in that particular case, the grand juror wanted to talk to educate the public on how the grand jury works. I submit to the court that's already happening here outside of anything we're doing or our client is trying to do. That discussion is going about already. Furthermore, that individual desired to participate, and I believe the words were pretty close to participate in the conversation about race relations. That's not what we're raising here. We're not trying to be a part of some global discussion about race relations. Certainly that's very important. When we watch the news and we read media reports, these are things that are going on in the country. But our client wants to talk about their service on this grand jury. They don't want to educate the public on the grand jury process. That is, for better or worse, for lawyers and judges to do, for legislators to do, to make sure that the public has that opportunity and awareness. That's not for our client, and it's being done. Our client is not requesting to pontificate on race relations for the general public's benefit. They want to speak directly to what the Attorney General's office did and said about this particular proceeding. They also cite the Greenwell case, which I think we cited in our motion as well, which is one of the cases that comes up a lot with grand jury secrecy. It's got some really interesting language giving the posture of where we are now, since it talks about the need of secrecy to shield the proceedings of the grand jury from public scrutiny. Well, we dropped the ball on that one because it's all out there and it's being scrutinized bigger than anything anybody's seen in this county that I could ever recall. But the shield was being forged during those proceedings for the Attorney General to use it to block off whatever it is they don't want to talk about, whatever they don't want to be definitive about, whatever they don't want to be unambiguous about, whatever they don't want to keep pointing back to the grand jury about. And the purpose there, and they go back to the McCulloch case about that, which is the Missouri, is shielding witnesses from threats and bribes and things of that nature. The witnesses are out of the bag. The recordings are out there. Some redacted, sure, but not all. They're going to be filed publicly in discovery, as they should be. They're going to continue to get out there. The jurors, and this reminds me of something that they put in the intro to their response. They called the jurors' request to remain anonymous the paradox of all paradoxes, because they want to talk, but they want to be anonymous. Here's something that I think we can't lose sight of, given their cavalier attitude towards that request to remain anonymous. Grand jurors are not entirely secret individuals anyway. They talk to their employers about their service so that they can make sure they're not losing their job, that they're adequately keeping up with whatever they need to as far as their payment with their employers. They tell their family. Both sides have pointed this court to the Jefferson County Handbook for grand jurors, which very much states their freedom to discuss those things. This is a case of a magnitude that within the last 5 days, Mr. Cameron has been on 2 different shows on Fox News to talk about it. That's a big deal because it's getting all the way across the country. It's not just Louisville, Kentucky. These people go to work. They live with their families who know that they served. It's unimaginable that if somebody wanted to try to trace that back somewhere, they couldn't at least figure out who a handful of grand jurors were and then try to figure out if they were a part of this motion or not. So perhaps before they use words like paradox, they should look up alternative meanings where sometimes the paradox means that it looks like something that's impossible that later turns out to be true. And in this case, it's a very accurate reflection on our client that they want to remain anonymous because they're already exposed. And they're exposed because of the Attorney General's statements. They're exposed because they had to tell their employers and their family and friends what they were doing. They're exposed, at least one of them is, because they're the foreperson and they have to sign the indictment. If anybody pulls that out of public record and recognizes the signature, they're going to know who it is. So it's not some paradox of raising an issue that makes no sense. It makes an abundance of sense. They go back to RCR 5.02, and this has been a big part of their messaging over the last week, that the grand jury has the right to lodge charges for anything that comes to their attention. All this conversation that we all agree, the rules and the law states the grand jury is an independent body. They're not answering to the prosecutor, so to speak, under the rule. The court has more control than the prosecutor does. But only until recently did the Attorney General's office start talking about later in the rules where they have to act as an advisor to the grand jury. Essentially, they guide them through the process. As a practical matter, For all the lawyers that are in this virtual room and the court itself, we all know how that works. The prosecution guides them by presenting charges. Now, that's not to say that a grand jury unanimously, by the way the law works, can't say, hey, we have questions about this charge or we want to look at another charge. But I would submit to the court in a practical application, when you're dealing with things as technical as different degrees of homicide, that it would be almost unheard of for 12 lay people to say, could you go back there, Mr. or Mrs. Prosecutor, and draft up a manslaughter in the second degree? We feel like maybe that might work. How about a reckless homicide? Can we have a green book? Can we read the rules in the commentary? That doesn't really happen. And then you get a situation like this case. And obviously, I'm not arguing either way on what should have happened in the grand jury as far as indictments. That's not our client's fight. It's not our client's issue. But when you look at 503.120 Section 2, self-defense, and how it applies to innocent bystanders, it's one of the most complicated statutes in criminal law. These are 12 lay people. They're not going to know how to ask all of those questions. Now, I don't know how much time the court has had to invest in the 15 hours of the recordings. But sadly, what you hear on the recordings is they ask pointed questions. This was an active panel. This was a very astute panel that was definitely paying attention. And they asked very good questions that could have led in that direction that were shut down, cast aside. Sometimes told, we'll come back to that later, which they don't. Asking questions about, one witness versus another, things of that nature. I won't belabor the point, but they were trying to ask questions and they were not getting the answers. And I submit to the court that's a dereliction of duty by the prosecutors that presented the case because they didn't answer the questions. They didn't respect the authority of the grand jury to ask them and to guide them along that process. We get to, I think, Section 4 of their response talks about how a declaratory action is contrary to the very verbiage of RCR 5.24, which essentially is where we're all living in this case and in this argument, is under Section 1, what applies and what doesn't. Now, they took some effort in their 22-page response to talk about how we phrase things in our motion. That's fine. I took some issue with things they phrased in their response that I've already discussed. But the plain language of the rule talks about all portions of the proceedings, regardless of recordings, remain secret unless a court decides otherwise. The court has vast discretion to disclose that. In fact, Judge Ann Bailey Smith did it at arraignment on the resulting indictment, released the recordings. But what I submit to the court that 5.24 Section 1 also includes what's not recorded. The court absolutely has the authority to allow a grand juror, a prosecutor, a witness, whoever may bring the issue to the court, the right to discuss these things without fear of retribution, prosecution, or being held in contempt, or being held civilly liable for that disclosure. Here's the thing. In their response, they're leaning on this secrecy that they've already opened up multiple times. And as I stated, Mr. Cameron has made public appearances where he's laid some things at the grand juror's feet, walked it back a little bit, but then he's all over the TV talking about how comfortable they are with their case. When he was on WDRB for an exclusive interview, he stated, and I quote, "I'm not afraid of any judgments or recommendations that we made. We presented all the facts that we uncovered in this investigation. The fact of the matter is we're confident in the presentation that we put forth. Whether this grand jury speaks out or not, that's of their own accord and their own volition. I don't have anything to do with that specifically," end quote. He later goes on in the very same interview to state, and I quote, not hiding in any way in regards to accountability, but rather we're honoring the tradition of keeping the confidentiality of grand jury proceedings. He came back to it at the very end, but he's clearly stating he has no concern until he has to respond to this motion. Then all of a sudden it's a concern. He states on Tucker Carlson's show, and I quote, "I led with the facts and the truth and had that lead to the conclusion." I picked that quote out of his appearance because I think it's important to note that he doesn't mention the law in that statement. And that's one of the very questions that has been left unanswered, is when you lead with the facts and the truth to get to your conclusion, you got to take it through the law first, especially as the attorney general, especially as a prosecutor presenting a case to the grand jury. If you don't adequately explain the law, if you don't answer their questions, if you don't go down the path they're leading you to, then you're not upholding your duty to put it through the law and to adequately address these concerns. And Judge, I'll try to wrap up. I know sometimes I get a little long-winded. They mentioned in their response that there was no request for limitation of disclosures. They're right. But let's remember the timeline here. When our client filed the motion, nobody at that time, when it was being drafted or when it was filed, was aware the grand jury recordings were going to be released. There had been no response from the from the attorney general in relation to what our client raised in the motion. Now, obviously, a lot has played out in that time frame. There have been direct statements in response. They've filed their response in writing, as they're absolutely entitled to do. We did not tender an order with our motion because we knew there would be an evolution from the time it was filed to the time that it got in front of the court. We absolutely respect the court's acumen in this realm as well and are open to limitation. This is not necessarily an unfettered deal where our client wants to disclose a whole bunch of names of grand jurors. That doesn't even make sense. They want to remain anonymous themselves and discuss what they think is counter to what's been put out there publicly by the attorney general because of their own fear of being held in contempt, which I submit to the court is exceedingly valid and likely based on the 22-page response. They don't want to subject other jurors to those fears any more so than they may already have. We're not speaking for any other jurors, but it stands to reason they may feel similarly as far as being held to public scrutiny, to being dragged through the media and held responsible for certain things that, according to Mr. Cameron's own quote, he's not afraid of that accountability, even though he puts it on people that can't speak out. So the court can look at that and limit it however you see fit. But again, we're not seeking to disclose names. We don't want to disclose witness names that have been redacted. We respect the privacy rights of everybody involved. But when you open the door by discussing evidence directly, so much so in that press conference for lay people, it was probably hard to understand if Mr. Cameron was talking about his group's thoughts on the evidence or if he was actually talking about the grand jury's deliberations. It was that unclear the way he discussed it. It was that open the way he discussed it. You can't say you don't want somebody to respond to definitive statements you're making about what they did when you're out there talking about all of it and then sit back and say, well, I'm sorry, you don't get to do that because it has to be secret. So whatever limitations the court may put on it, we are fine to handle however the court may deem fit. If the court wants us to file something in writing under seal for a review by interested parties and the court prior to making a ruling, fine. We can do that. If the Attorney General's office wants to communicate with us instead of talking about us on TV and filing motions, we're more than happy to discuss with them the problems we have with those statements and how we think they are more appropriately addressed to the public so that the actual truth of what happened is being presented in the right way. So the argument about unfettered discussion and not having proper limits, I get it. It was a fair thing to put in their response, but we're on record right now telling you we're open to that discussion, both with the court and with the Attorney General's office. We haven't had those discussions yet. And I know Mr. Maddox is going to take the floor here in a minute, and I'm not putting that on him or anybody else in that office. We didn't reach out to them either. So I don't want anybody to sit here thinking I'm bad mouthing how the Attorney General's office has handled the legal mechanisms here. We're not doing that, but we're being very open and very candid that we will discuss freely with people how we think we can do this within the proper realm and within the proper limitations so that we're not necessarily opening Pandora's box as they may have you believe. I don't think that's what's happening here. And, for all those reasons, Judge, we think that the issue is ripe. We think that our client has clear standing, as noted by cases they attached their own response. And any deficiencies, I'll come back to it briefly, with filing, service, et cetera, that are not cured by the actual notice and things of that nature. If the court wants to tell us to do something, we're going to do it. If they have a specific request on something they'd like us to refile or do differently, fine. I don't think that cures the issue. I don't think that anything rises to the level of dismissing when they clearly had an abundance of notice and responded to it within 5 hours or less publicly. So, Judge, we're asking that you grant the motion and that you give us some direction on how we go about it. And if that involves, discussing things with the Attorney General's office and coming back to the court, we're open to that. If the court wants to have another proceeding after we've had some time to discuss amongst ourselves, we're open to that. But again, it's a ripe issue. Standing is clear. The issues that are raised are of the utmost public interest, and any secrecy interest has been waived essentially by the Attorney General's office based on their own public statements. So, Judge, we'll submit and stand on our arguments and listen to counsel for the Attorney General. Thank you, Judge.
Okay, thank you. Before I get to the Commonwealth, I do have a couple of clarifying questions for you, Mr. Glogauer.
Yes, Judge.
As you pointed out, since this motion was filed last week, the situation regarding the availability of discovery in the grand jury recordings has evolved. So the grand jury recordings have been filed in accordance with Judge Bailey Smith's order. So is it your position that the only information that remains secret at this stage is the grand jury's deliberations itself?
Not necessarily just their deliberations, but anything contained within those 2.5 days that is not recorded. Specifically, we've talked about this publicly. What was presented? What recommendations were made? Yes, but also what was actually presented? What questions may have been asked by our client? And how were they answered relative to that?
Are you suggesting that there was evidence presented that was not included in the recording?
I think there were questions asked that are not included in the recording.
Okay.
I can't speak to to evidence itself. It's my understanding, and again, the caveat being, I'm sorry, I have not listened to all 15 hours of the recordings. I've had extensive discussions with my client. I'm about 13 and a half hours into the recording, but it's not our position that there is some evidence that maybe is not out there. It's more about the discussions that were held directly with the prosecutors that is not contained in the recordings. We're not interested in necessarily discussing what the jurors discussed amongst themselves. And I would submit they're probably right. That's probably not appropriate unless another juror joins into this action and wants to discuss that openly as a conversation they had with our client, or multiple grand jurors get involved. So I hope that answers the court's question as best I can.
So your client does wish to remain anonymous?
At this time, yes. And I'll be candid about this as well. That is also an ever-evolving process. But until our client can be certain that there's not some fear that they're going to be held in contempt, that the level of scrutiny is not going to be unbearable, that is their desire. Obviously, some of that is subject to whatever happens with this action. And quite frankly, that's why the client decided this is what they wanted to do, was to get that clarity so they can further make that decision. But as I stated, there could be a way that, maybe everybody's a little bit more happy with how it gets handled, and something gets submitted in writing that preserves that anonymity, takes care of some of the concerns the Attorney General's office has, and gets submitted publicly so that there's that definitive statement out there. That's not for us to decide. But as far as, to succinctly answer your question, which I'm terrible at, but to succinctly answer your question, at this very moment, that is still their desire.
Okay. All right. All right. Thank you. Mr. Maddox?
Thank you, Judge.
Thank you, Your Honor. When I read Mr. Glogauer's motion or petition, I concluded that it sought to undermine the foundation of the criminal justice system in the Commonwealth of Kentucky, and more specifically, the grand jury secrecy that is the foundation of that system. After hearing his argument today, I have no doubt that that is what he and his anonymous clients seek to do. It is impossible to imagine a motion that would be more effective in running counter to 200 years of jurisprudence in this state and 250 years in the United States of America than a motion seeking to have a grand juror who has been discharged given free rein to discuss at will the deliberations of that grand jury. As our response made clear to Your Honor, both the Commonwealth's Chief Law Officer, Attorney General Cameron, and the Commonwealth's Attorneys Association, representing every Commonwealth's attorney, every state prosecutor in the state, have grave concerns for the implications of what this motion seeks from Your Honor.
Do you represent the Commonwealth's Attorneys Association as well?
No, Your Honor, but our response includes a statement by that association at Exhibit 2. And I think it's important to point out that the Commonwealth's Attorneys Association believe that the historical protections, in their words, of grand jury secrecy are important and should not be set aside because of the dissatisfaction of a party or a grand juror. More importantly, setting aside the important safeguard of secrecy because of disagreement with a result is essentially setting it aside for no special reason at all. And I think that our response makes clear that both at the Commonwealth level and at the federal level, the law is clear that hardly setting aside secrecy for general unhappiness on the part of a grand juror. What is required is a particularized showing of some special reason for doing so. And I think, Your Honor, the case law that we've cited, starting with Procter & Gamble, but continuing with a variety of cases from the Kentucky Supreme Court, make clear that this is typically something that happens when a defendant in a trial needs grand jury evidence to protect an important individual or constitutional right, or there is some other special circumstance that allows specific evidence and particular parts of grand jury presentations to be made public or to have the secrecy removed. This is as far from that kind of case as one can imagine. In fact, Mr. Glogauer's client, anonymous juror number 1, has made literally no showing at all of any particular need. Instead, what we have been told, apparently, is that the anonymous grand juror is unhappy with a press conference that was given by Attorney General Cameron on September 23rd, 2020. And Mr. Glogauer has suggested to Your Honor that because the Attorney General held a press conference that had been anticipated on a national basis for months and was something that probably had a higher degree of interest in both the Commonwealth and in the United States than many press conferences ever given by a state attorney general, that somehow he's suggesting that merely having that conference and satisfying the public interest in understanding the nature of the grand jury determination, the nature of its findings, and the reasons that it returned an indictment only for wanton endangerment on the part of one of the officers involved, that should somehow never have happened. Mr. Glogauer's suggestion that somehow the Attorney General Cameron himself removed the veil of secrecy that governs grand jury proceedings is simply not accurate. And in fact, I will refer Your Honor to the case that is most like this one that we have briefed for Your Honor in our response, and that is the case arising out of the Michael Brown officer-involved shooting in Ferguson, Missouri. There are two cases that flowed from that proceeding. One was Doe versus McCulloch, Doe being an anonymous grand juror, and McCulloch being the prosecutor. In that case, Your Honor, the prosecutor himself had a press conference. And like this case, Your Honor, the Michael Brown case in 2014 had an incredible degree of national attention. And I don't need to tell Your Honor that. On November 24, 2014, the Wilson grand jury in that case, the grand jury considering whether to indict Officer Darren Wilson, who was involved in the shooting, returned a no true bill, and the grand jury was discharged. And this is in the case, Your Honor, that we cited to Your Honor, Doe versus Bell. This is from the Eighth Circuit, the United States Court of Appeals, sitting in St. Louis. In that case, McCulloch, the prosecutor, held a press conference at which he delivered an oral statement and released some of the evidence, some of the testimony presented to the grand jury, including transcripts, reports, interviews, and forensic evidence. Now, that case involved a grand juror who sought to do exactly what Mr. Glogauer's client seeks to do here: be relieved from the requirement of grand juror secrecy and be allowed to speak freely concerning her experiences, the deliberations, the evidence, and the conduct of the prosecutor and anyone else who presented to the grand jury. Now, what's remarkable about this case, Your Honor, is that there was no true bill returned in that case. In other words, there was no subsequent criminal trial that flowed from that grand jury proceeding. And yet, both the trial court in Missouri, the Missouri Court of Appeals, the United States District Court in St. Louis, and the United States Court of Appeals for the Eighth Circuit, 4 courts asked to consider whether the important, in fact, the vital principle of grand jury secrecy should be set aside in that case because one grand juror disagreed with the propositions offered by the prosecutor in connection with one of the most highly publicized case in recent history. And in those cases, in all 4 of those courts and in those cases, the answer was no, it should not be. And for all the reasons we've cited in our response. There is nothing more important, frankly, than the foundational principle of grand jury secrecy. Now, this case differs, Your Honor, because there was an indictment returned by the grand jury on which anonymous grand juror number 1 sat. And that indictment, as Your Honor well knows, was referred to Division 13 and Judge Ann Bailey Smith in the Jefferson Circuit Court. That case is currently being prosecuted by the Attorney General's office. And so the reasons to maintain the secrecy of the grand jury proceedings in this case are substantially stronger than the reasons that led 4 other courts to consider the very arguments Mr. Glogauer has made to Your Honor over the last 45 minutes and to reject those arguments. In fact, the Court of Appeals decision from the 8th Circuit was just decided 2 months ago. And I think under the circumstances, it would be extraordinary for this court to reach a different result. There is nothing about this case, Your Honor, respectfully, that is more highly charged than was the Michael Brown case and the aftermath of that case in Ferguson, Missouri. I will also point out, Your Honor, that the suggestion that that evidence was presented publicly that somehow counsels in favor of removing grand jury secrecy is simply not the case. The 8th Circuit considered that very argument and concluded that the sorts of statements and the sort of discussions by the prosecutor at a press conference of that nature is not the sort of disclosure that leads to some sort of opening of the door or some need to throw open the proceedings. And in fact, what Mr. Glogauer's client is trying to do is exactly what the court in the McCulloch case, first the trial court in St. Louis, and then the Missouri Court of Appeals found to be objectionable. It said, affording a grand juror unrestrained ability to disclose her interpretation of what happened in the proceedings completely destroys the idea of secrecy, which is crucial to the proper functioning of the grand jury process. The secrecy requirement promotes vitally important interests, such as protecting the jurors themselves, encouraging prospective witnesses to come forward and speak candidly, protecting the integrity of the grand jury process by shielding witnesses from threats, bribes, or other means. Your Honor, it's no secret that in Jefferson County, Kentucky, this year, the murder rate is up 80% over 2019. The last I looked a few days ago, there had been 128 murders in this county compared to 70 all of 2019. One of the big problems that police and law enforcement have is having witnesses come forward, witnesses who have evidence that would lead to the arrest and conviction of criminals. And when witnesses are afraid that their testimony may become public, that leads to less cooperation and fewer witnesses overall. That's one good reason why grand jury proceedings must be maintained.
Aren't the witnesses' testimony already public at this stage, though, in these proceedings?
It is, Your Honor, although so far as I know, the names have not been disclosed. My understanding is that when the tapes were presented, Judge Smith ordered the redaction of personally identifying information, names. It is true that voices may be recognized, and that's an unfortunate consequence of the disclosure of the tapes. And I think, Your Honor, it's one of the reasons why grand jury proceedings and the tapes are almost never made public.
But the Attorney General's office didn't challenge Judge Bailey Smith's order to provide the grand jury recordings, right?
That's correct, Your Honor.
Okay.
The other reason, Your Honor, that the McCulloch Court found for the importance of maintaining the secrecy of grand jury proceedings was a reason that was articulated by the United States Supreme Court in the Douglas Oil case. And that case was just from 1990. And it says that even when a grand jury has been discharged, as in this case, the possible effect upon the functioning of future grand juries is one that counsels in favor of maintaining secrecy. Persons called upon to testify will consider the likelihood that their testimony may one day be disclosed to outside parties. Fear of social retribution or social stigma may be as powerful deterrents to those who would come forward and aid the grand jury in the performance of his duties. So concern as to the future consequences of frank and full testimony is heightened where the witness is an employee of a company under investigation, et cetera. And this was a case, Your Honor, where the court concluded that it is highly inappropriate to allow the sorts of disclosures that Mr. Glogauer seeks here. The McCulloch case concluded with this. In that case, it said that the grand juror, Doe, ignores the fact that some reasons for secrecy extend. I'm sorry, that's, Your Honor, what the jury concluded was that the disclosures Doe wishes to make, this is again in the McCulloch case, involve the essential functions of grand jury proceedings and the jury's ultimate determination of whether there is sufficient evidence, i.e. probable cause, to indict a criminal suspect. And when that is the case, there is almost no reason for unveiling the grand jury proceedings from the veil of secrecy. Your Honor, Mr. Glogauer said in his statement that he wanted to be able, his client wanted to be able to speak about what was said and what was done. Now, if I remember his motion correctly, he emphasized repeatedly that he really wanted to be able to speak about what was not said and what was not done. I think now the argument he's made today makes clear that that was, in fact, as we said in our response, wordplay. What Mr. Glogauer and his client seek is an unlimited opportunity, unfettered discretion to speak about the grand jury proceeding, the presentation of evidence, and the deliberations of the jury. If the question is this only about the Attorney General's recommendation? We know the answer to that already, Your Honor. Attorney General Cameron has made clear that the recommendation to the grand jury was for the wanton endangerment charge against the single officer, and that there was no recommendation of a murder charge. So Mr. Glogauer's motion uses the language that this office has somehow foisted the responsibility onto the grand jury. That's simply not true. I think it's clear from the press conference on September 23rd that the process that has been followed in grand juries throughout the Commonwealth for centuries at this point, certainly decades in modern history, was followed in this case. And as our papers make clear, and as the Commonwealth's grand jury handbook makes clear, we've cited for Your Honor, the prosecutor, the Commonwealth's attorney, and in this case, the special prosecutor, the Attorney General's office, is the legal advisor to the grand jury. The grand jury consists of lay persons. They do not have legal training. It is frankly inconceivable to think that a prosecutor would not make a recommendation to a grand jury after instructing them and advising them on the relevant statutes, the relevant legal doctrines, and the application of the law to the facts that the grand jury obtains. So that is really, frankly, I believe, Your Honor, a very large red herring. Mr. Glogauer claims that at this point the public interest would be served by complete and open transparency, I'm going to suggest, Your Honor, that nothing would undermine the public interest more than for this court to throw out the entire body of law of grand jury secrecy, the reasons underlying that, and the functioning of the grand jury in the Commonwealth by ordering what Mr. Glogauer calls complete transparency. There is a long and storied body of law, a history and a practice and a custom of maintaining the secrecy of grand jury proceedings, notwithstanding the interest insofar as it goes in any given case in transparency. But the functioning of the criminal justice system, which depends on the grand jury itself, cannot survive, Your Honor, if the grand jury may throw open its doors after it is discharged and 12 grand jurors be given free rein to run to the microphones, the newspapers, the internet, and wherever else they might choose to discuss the proceedings that they took an oath to maintain as secret. So I think, Your Honor, the notion that somehow the public interest is served and that transparency is more important than the grand jury secrecy here is simply belied by the facts. Truthfully, were Mr. Glogauer's motion to be granted, it is more likely that the result would be throwing gasoline on a fire, because the entire process would then be reopened and every grand juror would then be at risk of being sought out, identified, and put in front of cameras, put in front of microphones to present their own view of the matter. And Your Honor, it's important to remember here, it's not as if a grand jury acts unanimously. All we know is that Mr. Glogauer represents one anonymous grand juror, or it may be two, I'm not sure at this point. But Section 248 of the Kentucky Constitution makes clear that a grand jury need only have 9 members vote to return an indictment. So inevitably, there are grand juror members who are unhappy with the proceedings, who are dissatisfied with the presentation of evidence, who have some belief that a different result ought to have been reached. It cannot be the case, Your Honor, that in any case in which a grand jury acts less than unanimously, simply because of an interest in transparency or a personal notion or belief that the public interest would be served by that grand juror presenting his or her personal views and personal experiences concerning the grand jury's deliberations to the public. And I think that that is self-evident. Your Honor, one of the important rules that underline the notion of grand jury secrecy, and the reason why it has been so venerated in the Commonwealth of Kentucky, and indeed going back to the very founding of the United States of America, the grand jury clause is part of the Fifth Amendment. And the courts have said that that it is an integral part of criminal justice in America. I think that the Seventh Circuit pointed out in a case in 1984, Your Honor, called Illinois versus F.E. Moran, quote, "The view that grand jury secrecy is very much worth preserving even after the grand jury has been discharged is far too well established to be questioned." That was Judge Posner of the Seventh Circuit. the Supreme Court has repeatedly ratified that view. Procter & Gamble, the Douglas Oil case, Butterworth case, and others. And we know that in Kentucky, the grand jury secrecy can only be lifted when there is some particularized showing. One of the important principles, Your Honor, was articulated by our Supreme Court in Democratic Party of Kentucky versus Graham. That's a case just from 1998. And what happened in that case, the court said that the grand jury may not file a report reflecting on the character or of a citizen or officer not indicted. Now, we know in this case that there was one officer indicted. He was indicted for wanton endangerment. 2 officers were investigated and no indictment was returned against them. The names are public. There's no question about their secrecy, but it would be completely inconsistent with the Kentucky Supreme Court's teachings on grand juries to allow one grand juror to be relieved from the veil of secrecy and the oath that that grand juror took, to then go publicly speak about that person's view, which may or may not be the case, but one can assume that other officers should have been indicted. There is nothing more inconsistent with the proper functioning of the grand jury, Your Honor, than to allow one grand juror, or even the entire minority on the grand jury, if there was one, to publicly impugn the character, the reputations, the service of unindicted subjects. So, as we know, the secrecy can only be set aside to contradict a witness or at the trial of a defendant who needs that evidence, Your Honor, and nothing of that sort has happened here. And I would remind the court that, as I've said, the trial of the one indicted officer is now pending. And that court, Your Honor, likely has jurisdiction over the grand jury secrecy obligation. It is certainly possible when you go to the standing argument, Your Honor, one of the needs for standing is that there be a concrete interest. And as far as declaratory judgments are concerned, there needs to be the opportunity for a ruling from this court to definitively resolve the matter. I'm not an expert on the way in which one division in Jefferson Circuit Court works in conjunction with another when there are different cases pending, but the judge in the Division 13 case, Judge Ann Bailey Smith, might well have a different view of the need to preserve grand jury secrecy. She, after all, is charged with conducting a fair trial of the defendant in that case. And it may well be the view of that judge, Your Honor, that by no means should grand jury secrecy be lifted while there is a pending case that flowed from the very grand jury that is in question here. Your Honor, just one moment, please. I might also point out, Your Honor, that you asked Mr. Glogauer if his client wishes to remain secret or anonymous as a result of this proceeding. And I think the answer was yes, for the moment, or yes, until the answer becomes no. And the truth is that there is no right to proceed anonymously in a proceeding of this sort. We've cited, for Your Honor, the case law standing for the proposition, I believe it's the Tackett case from the Supreme Court and the McCoy case from the Court of Appeals, for the proposition that in the case of children or juveniles, or in certain other very limited circumstances, the right to proceed anonymously has been granted. But in this case, none of those factors apply. So it's not at all clear
Didn't the
why.
juror in the Doe v. Bell case proceed anonymously? I'm assuming that juror's name was not actually Doe.
That's right, Your Honor. That wasn't an anonymous case. I'm not sure what the Missouri case law governing proceeding with a pseudonym is. We've cited, for Your Honor, in our response, the controlling case law in Kentucky, which I believe makes clear that except only in very limited circumstances should that proceed. In fact, there was one case involving the claims against the archdiocese and the abuse of parishioners, that the court made clear to point out that part of the problems that were addressed in the case arose from the fact that Senior Judge Potter, who had presided over that case, allowed the case to proceed with anonymous plaintiffs. And the court suggested very strongly that even in that case involving intimate details and embarrassing circumstances, the use of a pseudonym was not proper. So we raised that for Your Honor. Finally, I would just say, Your Honor, that as far as the standing goes, it is the court, the Jefferson Circuit Court, that has the contempt power. Mr. Glogauer has made suggestions that this office would move for contempt. I can't say what would happen if a grand juror unilaterally chose to disregard his or her oath, but it is certainly the case that it is not within the power of this office to hold a grand juror in contempt. And so, one of the requirements of an effective declaratory judgment and of standing is that the injury be traceable to the defendant. In this case, I don't believe the facts and circumstances giving rise to the motion would allow that conclusion. So, Your Honor, I think that under all the circumstances, it's clear in this case that the Supreme Court of Kentucky has made abundantly clear that grand jury secrecy is fundamental. It has been the bedrock of our criminal justice system for as long as the modern criminal justice system has been in place, and before that as well. There is a nearly uninterrupted line of authority from both the Court of Appeals and the Supreme Court making clear that only in extraordinary circumstances, based on a specific and particularized showing, should grand jury secrecy be lifted. And the truth is that there is nothing in Mr. Glogauer's motion that would allow Your Honor to reach the conclusion that such a showing has been made. And beyond that, Your Honor, the question of the public interest is simply not one that a single anonymous juror and her counsel ought to be allowed to determine when both the General Assembly of this state, the Supreme Court of this state, and every authoritative body that has ever weighed in on the topic agrees that grand jury secrecy is of paramount importance. And I would just close, Your Honor, with again, the statement of the Commonwealth Attorney's Office. They say that while the rules allow this court to direct the lifting of secrecy, the emphasis placed on secrecy by the rules dictates that court not waive secrecy requirements without a legally compelling reason. Again, Your Honor, this is in Exhibit 2 to our response. Individual dissatisfaction with a grand jury proceeding or with another grand juror, or importantly, Your Honor, with the prosecutor's comments or legal interpretations are not compelling reasons to set aside the rules of grand jury secrecy. This case is certainly no different, and there has been no compelling reason, in fact, no particular reason at all other than a grand juror's dissatisfaction with a press conference that would allow the grand jury to be set aside. Your Honor, I should also point out that this office redacted only the names of juveniles consistent with the judge's orders. I may have misspoken earlier. As well as, I'm sorry, the names of minors, their addresses, and certain neighbors' names. So if I gave the impression otherwise, I apologize for that, Your Honor.
Okay.
Under the circumstances, let me just make one more point, Your Honor. Mr. Glogauer has suggested that he would be happy to talk with this office concerning the contours of any order that he might be seeking. He is correct that he had never contacted this office before filing his response, or his motion. We've had no substantive discussions of any sort other than through this hearing. And Attorney General Cameron is always welcome to hear from interested constituents, and certainly in this case, counsel such as Mr. Glogauer and his clients. So if he'd like to speak with us about circumstances of any public statements going forward, obviously we're happy to have that conversation with him. But in the meantime, I believe it's clear that Your Honor would be breaking with centuries of precedent, both nationwide and in the Commonwealth, for Your Honor to accept the proposition that the dissatisfaction of Mr. Glogauer's client with the public statements of the Attorney General are some justification for undoing the very foundation of our criminal justice system and the grand jury secrecy. So with that, Your Honor, I would ask that you deny the motion and dismiss the case.
Thank you, Mr. Maddox. I do have a couple of questions for the Commonwealth in follow-up. How does the Commonwealth square its argument about the body of case law preserving the secrecy of grand jury proceedings with RCR 524 and the language specifically that that secrecy is subject to the authority of the court at any time to direct otherwise? It looks to me like that rule was adopted in 1963, although I haven't seen all of the iterations of that rule to know whether that particular language was amended or added at some point. At least that rule itself has been in effect since 1963. That language seems very clear, and it doesn't seem to place any particular burden or restriction on the court when the court directs otherwise. It says the court at any time to direct otherwise. How does the Commonwealth square that with the body of case law it's cited here today?
Well, Your Honor, thank you for that question. First of all, the rule dates to 63, but the criminal code preceded that rule. And I believe the criminal code, in one form or another, providing for grand jury secrecy, dates back well into the 19th century. As far as the limitations on Your Honor's discretion,
Mr. Maddox, your internet seems to have frozen. Oh, I think we just lost him. It's back on. Let me see. Okay, Mr. Maddox. All right. I think we lost you. You said as far as the restrictions on the court's authority to direct otherwise. And then
correct, Your Honor. Right. As far as the restrictions go, I think first of all, it's unclear precisely which court the rule refers to. I know that Your Honor presided over the grand jury and received the grand jury's report, but I believe it was when the day that the grand jury returned its findings, Your Honor drew Division 13 randomly and assigned the criminal case.
I didn't. Let's be clear. It was the foreperson of the jury who did
Okay,
that.
I'm sorry. Well, I apologize. That's why I'm in the civil division, Your Honor. But I know that the case in the criminal proceeding was transferred to Division 13. As I indicated earlier, that judge is now, and that division is now conducting a criminal trial. And it's not clear to me, and I confess that I haven't researched it and briefed it sufficiently for the response we filed last night, whether Your Honor has jurisdiction to grant the motion or whether that court would be the court handling the criminal trial. So
Are you saying that Judge Bailey Smith would have jurisdiction to make that decision?
Well, I believe that under Criminal Rule 5.24, the court does, and the court now handling the criminal proceeding is Judge Ann Bailey Smith.
So 2 questions. Are you saying that this court does not have jurisdiction to make this decision? And 2, are you saying that Division 13 would have jurisdiction to make that decision?
I think there is a serious question, Your Honor, whether you in Division 2 have jurisdiction with the criminal proceedings having been transferred to Division 13. I mean, obviously, at any point in that trial, there could be a particularized need for the release of some part of the information from grand jury secrecy. The defendant might himself make that request. There could be some other reason. So whatever Your Honor decided on this motion, Judge Ann Bailey Smith would at least, I believe, have concurrent jurisdiction, and it's conceivable, given the circumstances with an ongoing case after the return of a true bill, that she would have exclusive jurisdiction. Your Honor, we have not briefed that in our response in any length, so I hesitate to give you a definitive answer from this office today. As far as the remainder of your question, since 1963, there have been any number of cases. In fact, I believe most of the case law we've cited, for Your Honor, is more recent than 1963. The Brandsburg versus Miggs case is from 1971. We cite that on page 12. The grand jury is the bulwark of freedom specifically recognized in the Constitution and deeply embedded in the philosophy of human rights dating back to English law. The Matthews versus Pound case, Your Honor, is from 1966. Both of those are what is now would be the Supreme Court of Kentucky. And Matthews versus Pound, I think, made clear that it's only in very limited circumstances where the grand jury secrecy should be lifted. The Graham case from 1998 says the grand jury is an institution of constitutional origin, and it is an instrument of the people, not an arm of the police. So I think there's no question that, notwithstanding the current text of the rule dating to 1963, the inherent limitations on the court's discretion that have been articulated by the Supreme Court, earlier the Court of Appeals and the current Court of Appeals, have as much force now as they did. And in fact, the reality is the specific language of the rule, I think, is immaterial. I suspect it's always been the case that a trial judge such as Your Honor, has had some discretion to allow for grand jury material to be made public, certainly in the context of a criminal trial. But I don't believe there's any authority for the proposition that that means that your discretion is untethered to the principles that make grand jury secrecy the very foundation of our criminal justice system.
And my final question, at least for now, is you alluded to the possibility that allowing a grand juror to speak about its deliberations and process may undermine a fair trial in the ongoing case in Division 13. Can you be more specific about that? How would that undermine Detective Hankison's right to a fair trial? Do we still have Mr. Maddox? Curious. Mr. Maddox, can you hear me? There we go.
I think I'm unmuted now, Your Honor.
Okay. I started to ask a question. I don't know if you heard it. You alluded in your arguments that allowing a grand juror to speak about its deliberations and the grand jury process during its consideration of this case would possibly undermine Detective Hankison's fair trial in Division 13. How would allowing a juror to speak about the case from their point of view in this process, how could that undermine Detective Hankison's fair trial?
Well, Your Honor, it's very difficult to say. I, of course, do not know. I wasn't in the grand jury proceedings. I don't know what was said. I don't know what Mr. Glogauer's client might choose to say. And I think that your question itself highlights the reason that grand jury proceedings are presumptively secret and why the grand jurors are sworn an oath to maintain that secrecy. I imagine what the motion seeks is to have one of the grand jurors discussing freely his or her impressions, disagreements, specific takes on the evidence. I think one of the problems with getting a fair trial, Your Honor, in a case as high profile as this is finding a jury pool that has not been tainted by pretrial publicity.
But that cat's already out of the bag. Regardless of whether this grand juror is allowed to speak or not, you would agree that there's already more publicity than most cases like this ever see. So any concern about selecting a jury down the road for trial in Detective Hankison's case, I'm asking specifically, what about what this grand juror might say how would that affect Detective Hankinson's right to a fair trial?
Your Honor, respectfully, if I knew what the grand juror might say, I would be able to answer that question more specifically. I believe that it is plausible and reasonable to conclude that having a grand juror who voted to indict a criminal defendant speaking publicly without constraint regarding that grand juror's views of the criminal defendant himself, Mr. Hankinson, could seriously jeopardize his due process rights, could certainly lead to public condemnation, and is the very sort of thing that the case law that says a grand jury may not be called back to correct its work, and it may not issue a report, Your Honor, that calls into question the character or the conduct of a citizen or an officer who was not indicted. It is certainly possible, Your Honor, and I think probably likely, that Mr. Glogauer's client intends to raise questions about additional charges that might have been brought against Officer Hankinson. There's no doubt, there's no question that lawyers who connected with this case, probably lawyers listening in on this hearing, have raised questions about other charges that might have been brought. To have a grand juror who may or may not have disagreed with the results reached by the grand jury to go publicly in the midst of a criminal proceeding flowing from that very grand jury proceeding and raising questions, posing questions, suggesting additional charges, complaining about charges that were not brought, impugning the integrity of the prosecution team, if that's what she chooses to do, and otherwise addressing the proceedings. I find it difficult to believe that that would not raise serious questions of due process and the right to a fair trial that would certainly raise questions for the appeal that would inevitably follow such a trial. So it seems to me, Your Honor, that while we don't know specifically what Mr. Glogauer's client intends to say, in fact, all we've been told in the motion is that he intends to say things about matters that didn't happen. We now know from his presentation today that he intends to talk about things that did happen, but we don't know what anonymous grand juror number one might choose to say. And it seems to me that it would be extraordinary for this court to greenlight that kind of public presentation in the midst of an ongoing criminal trial.
Okay, Mr. Glogauer, do you have any response?
Judge, if I may briefly, just a few things. I think it's important to note again, Mr. Maddox keeps directing the court to the Michael Brown case out of St. Louis County, Missouri. And in fact, tried to make a distinction that was a case that was heard that resulted in a no true bill. And here we have a true bill as it regards to Detective Hankinson. He then just moments ago mentioned in response to your question that our client could want to discuss additional charges that were brought against Mr. Hankinson. A couple of things with that. Distinguished from the Brown case, all we have here is the true bill against Detective Hankinson. So if they want to submit today on the record, there were no other charges presented on Mr. Hankinson, Detective Cosgrove, or Sergeant Mattingly, that's something that I think the public would love to hear directly from them that can get around that question, because we didn't hear any no true bills when Your Honor read the report, which Mr. Maddox also keeps going back to, I think it's Democratic Party versus Graham that they cited, stating that a grand jury may not file a report that basically attacks the character of the unindicted accused. There was no such report filed. And again, we all know who the accused were throughout this process. That is something that Your Honor just referenced as far as potential issues with an untainted jury pool. That cat, to use your phrase, is out of the bag. But no report is being filed regarding those individuals that weren't indicted. Also, he just used the phrase public condemnation, which I'm assuming he meant towards the accused, Detective Hankerson, which is interesting language to choose in light of the rules of professional conduct as it relates to a prosecutor, that they're not supposed to talk about these things publicly to avoid that very issue unless it's to inform the public of the nature and extent of a prosecutor's action and it furthers their goal of law enforcement. And so what we have here are public statements that were made that necessarily raise some public condemnation concerns that have been made a multitude of times, but also, again, it directs it right at the grand jury, at least initially, who, by their argument alone, it would seem, did not hear these other charges. So that brings me to the suggestion that, you know, it was wordplay for us to state we want to be able to discuss certain things that did not happen. If charges weren't presented and that's an ambiguity through the prosecutor's statements, then that is absolutely something that did not happen that our client would like to discuss. It doesn't preclude them from also discussing things that did happen. So I think the wordplay is really coming out of their mouths and not ours. It's a situation of the court looking at it and determining what can and cannot be discussed. But I find that all very interesting. And then they also want to point to, you can't just, make this request because you disagree with a result. We were very careful in our filing, and we've been hopefully careful in our wording today. We're not weighing in on the result. We're not exposing jurors' votes. Mr. Maddox has presumed or assumed, I guess, that there could have been a minority that did not vote to indict Detective Hankerson. He's right. That could have happened. The law is clear. It only takes 9 of 12 to indict. That's not something that we're trying to discuss. We said that rather candidly in our initial argument. We're not trying to throw other grand jurors under the bus. That's not what we're here for. We're here to discuss certain mischaracterizations that have been laid upon the public that can rather easily and succinctly be cleared up, which is why the suggestion was made in our argument. And I'm glad that Mr. Maddox says that Mr. Cameron likes to talk to his constituents. Now, I'm not going to say necessarily if my client is his constituent or not. He does have a right to vote, so maybe he is, maybe he's not. But that would be great. We'd love to talk to them. We'd love to potentially submit things to the court to see what exactly it is, but still protect our client's ability to be free from that persecution and prosecution that is likely. Ultimately what we got from the Attorney General's office at 5 p.m. yesterday was 22 pages about not wanting to talk about what their actions really were and leaving it still on the grand jury. 22 pages that, I'm sorry, it's not lost on me, perhaps relates to the 22 rounds that may not have been discussed as far as charges go with this grand jury. So I think they're a little off base comparing it to the Brown case out of Missouri, because that was an actual no true bill. Those charges were presented. That juror, as we discussed, wanted to utilize a First Amendment argument that they're allowed to talk about grand jury proceedings just as a whole, because there was a similarity there that grand jury heard other cases before they heard the Brown case, much as this one did. They were in service for some 2 weeks, I guess, before the presentation of the Breonna Taylor case. So sure, jurors could pontificate on the differences between the normal presentation and the one that was presented to this grand jury. That's already out there in the public. We don't need to play that role. What happened here is the Attorney General made certain definitive statements and certain ambiguous statements asserting what the grand jury did. But when the pointed questions, the direct questions that can be answered yes or no, or in one sentence, they get avoided. And they want to hide behind, this argument that there's 200 years worth of need for secrecy. Sure, that's what the grand jury has been. However, the court's right. The rule itself states that you have jurisdiction to release that however you see fit. Quickly, and I'm going to touch on the jurisdiction argument there. I suppose there could be an argument they make of joint jurisdiction with Division 13, although at least in Jefferson County, there's a grand jury judge every month. That was Your Honor. That's why this motion was filed in this court, because Your Honor, it's our belief and understanding under the rules that you were in charge of that panel. It doesn't matter they're no longer in service. That was your panel that you were in charge of, and any other issue that could have been raised, whether they wanted to reconvene, which is something they could have done in theory. They could have filed that motion. Unfortunately, by the time we became aware of the concerns and our client's desire to file something, they had been released. They got released on Monday. And I see that Mr. Wine has joined us. I'm sure he would agree. They were finished because his office released them. So I think jurisdiction is very much appropriate here. I think the court absolutely has discretion. And I think the secrecy that they're hiding behind is really nothing more than not wanting to see what the prosecution does. And I think if you looked around this country, there are concerns that when things don't always see the light of day, they're not properly sanitized. They're not properly let out for the public to consider. And I don't want to get too far away from what we're actually trying to do. But, that could be a conversation that grows at some other point, but that's not the issue here. It's a very narrow issue. The only thing left that's not released are prosecutorial actions. So I would submit to the Attorney General's office, I don't know what you're hiding. The PIU file is public. The grand jury recordings have been released. Discovery will hit the file at some point. There will be more there. The only thing that's left are prosecutorial actions. So, it's starting to sound a whole lot like pay no attention to the man behind the curtain. And that's contrary to what this system is supposed to be about. And he did mention briefly, if our client or somebody wanted to impugn the prosecutors here, that's not really the goal either. The goal is to determine what the actions were and maybe, as we put in our writing, what they were not. And the only way that happens is if Your Honor grants the motion in some fashion. I've tried to make it very clear, and I didn't hear much in the response other than, Mr. Cameron is welcome to speaking to voters and lawyers and things of that nature. Great. I'll call him tomorrow if he wants to chat. I would love it. But they did not respond to talking about submitting something to the court for the review under seal that would narrow down what we're talking about to get around some of these concerns. So if the court's inclined to take this under submission, which I'm not presuming what the court's going to do at all, but if the court were so inclined and wanted to direct us to do that, we would. If the court wanted to direct us to have an exchange with the Attorney General's office, it would be our request that that exchange be protected under the law, whatever we may disclose in a proposed statement, then we're open to that as well. But I think what we're hearing in the response is it's difficult. I get it from Mr. Maddox's perspective because we can't really say exactly what it is we want to say. I'm not going to expose my client in an open courtroom. No lawyer ever would. But these grand jurors are already exposed to some degree by having served and by the statements that have come out of that office. And because of that, this is the remedy that was sought. And we think that there are ways that it can be fashioned that are very appropriate, that are well within the bounds of the law, and are certainly within the jurisdiction and discretion of this court.
Your Honor, could I just respond to one point?
Briefly.
Mr. Glogauer's suggestion that somehow we're hiding things and that there is a man behind the curtain is really inappropriate. This office has already said publicly exactly what we did and what was presented and how this process developed. What we are doing here today is protecting proper functioning of the criminal justice system in Kentucky. And it's not me saying that, it's every Commonwealth's attorney in the state that has said that to Your Honor in Exhibit 2. And I think that that statement is one that demonstrates that this case is larger than any anonymous grand juror and than any one case, and that it goes to the very foundation of how criminal justice is administered in Kentucky. So that's what this office is all about, and that's what we are doing by defending the principle of grand jury secrecy. Thank you, Your Honor.
Thank you. Okay, I am going to take this ruling under submission. I am mindful of the fact that the parties would probably like a ruling sooner rather than later, so I will get a ruling out as quickly as I can. Anything else on
very
this
much.
matter?
Not at this time, Your Honor. Thank you. Thank you, Mr. Maddox.
Thank you, Mr. Klugeauer. Thank you, Your Honor.
Thank you all. You may be excused. I'm going off the record.